When the Constitution grants Congress oversight authority, that power is not ceremonial. It is absolute. Article 1, Section 3 establishes the Senate's constitutional duty to provide advice and consent on matters of national security, foreign policy, and executive conduct. Federal law mandates that classified information be handled according to strict protocols designed to protect American intelligence operations, military personnel, and diplomatic relationships. These are not guidelines. They are requirements backed by criminal statute. Donald Trump is now facing formal demands for resignation from more than 100 members of Congress following revelations about classified documents found in unauthorized locations. The files reportedly contain some of the most sensitive national security information in the federal government's possession, including intelligence related to nuclear capabilities, covert operations, and foreign surveillance programs. This is not a political dispute. This is a constitutional crisis involving the mishandling of materials that could compromise American lives and national defense. Confidence in executive branch security protocols, congressional oversight mechanisms, and the rule of law itself is being tested in ways not seen since Watergate. When classified materials are removed from secure facilities and stored in locations lacking proper clearance, the damage extends beyond policy disagreements. It strikes at the foundation of how democracy protects itself from external threats and internal abuse. The Senate resolution calling for resignation was introduced with bipartisan support from members of the Intelligence Committee. These are not partisan activists. These are lawmakers with security clearances who have reviewed classified briefings about the scope and severity of the breach. Senator Mark Warner, chair of the Intelligence Committee, stated publicly that the materials in question represent some of the highest classification levels in the federal system. Documents marked Special Compartmented Information, or SCI, require handling in facilities specifically designed to prevent foreign surveillance. They cannot legally be removed from those facilities without authorization that flows through defined channels. What makes this unprecedented is the volume and sensitivity of the material involved. Federal investigators have cataloged more than 300 classified documents recovered from unauthorized storage. Among them, approximately 50 bear markings indicating top secret and SCI classifications. These are not routine briefing papers. According to sources familiar with the investigation, the files include intelligence on foreign nuclear programs, detailed assessments of military vulnerabilities, and information that could identify covert intelligence assets operating in hostile territories. The Presidential Records Act requires that all documents created or received by a sitting president in the course of official duties be preserved and turned over to the National Archives upon leaving office. This is not a courtesy. It is federal law. The Espionage Act, codified under Title 18 of the United States Code, makes it a felony to retain national defense information in unauthorized locations. The statute does not require proof of intent to harm the United States. It requires only that the individual knowingly retain the materials and failed to return them when legally obligated to do so. Court filings reveal that federal authorities issued a subpoena in May demanding the return of all remaining classified materials. That subpoena was not fully complied with. A subsequent search conducted under judicial warrant recovered additional documents that should have been returned months earlier. Legal analysts, including former federal prosecutor Glenn Kirshner, emphasize that obstruction of a federal investigation compounds the underlying violations. When someone is given a lawful order to return classified materials and instead conceals or moves those materials, they cross a line that federal prosecutors take extraordinarily seriously. The resolution before the Senate does not merely express concern. It formally demands resignation and warns that failure to comply will trigger impeachment proceedings in the House. Senate Rule 23 allows for expedited consideration of resolutions involving national security threats. The process is designed to move quickly when the integrity of classified systems is at stake. More than 120 lawmakers have signed onto the measure, including members who previously opposed impeachment efforts. That shift reflects the gravity of the evidence presented in closed-door intelligence briefings. Congressional investigators have been granted access to damage assessments prepared by the intelligence community. Those assessments reportedly identify specific risks created by the unauthorized storage of classified files. When materials concerning nuclear capabilities are stored in facilities lacking electromagnetic shielding, foreign intelligence services with sophisticated surveillance technology can potentially intercept or reconstruct sensitive data. When documents identifying covert assets are stored alongside personal records, the risk of exposure multiplies. Intelligence officials have briefed lawmakers that some of the compromised information could take years to fully assess for damage, because the scope of potential exposure extends across multiple allied nations and ongoing operations. Add to this the findings of forensic document analysis. Federal investigators employed specialists who examine handling marks, access logs, and metadata embedded in digital copies of classified files. The analysis reportedly shows that some documents were accessed, copied, or moved after the initial demand for their return. This matters because it demonstrates active engagement with materials that should have been immediately secured and returned. Prosecutors view post-subpoena conduct as evidence of consciousness of guilt, a legal term describing behavior that reflects awareness of wrongdoing. Meanwhile, the Department of Justice has convened a grand jury to evaluate whether criminal charges are warranted. Grand jury proceedings are conducted in secret, but court filings related to the investigation reveal the scope of the inquiry. Witnesses with knowledge of how the documents were packed, transported, and stored have been subpoenaed. Attorneys who represented individuals involved in the matter have been questioned about their knowledge of what materials were retained and where they were kept. When prosecutors bring attorneys before a grand jury, it signals they are building a case for obstruction or false statements in addition to the underlying classified information violations. The legal framework here is well established. In United States v. Sterling, federal courts upheld convictions for unauthorized retention of classified materials, even when the defendant claimed no intent to harm national security. The statute focuses on whether the individual knowingly possessed the materials and failed to return them when required by law. Intent to damage the United States is not an element prosecutors must prove. This removes a common defense strategy and narrows the legal arguments available. Compounding this pressure is the response from within Trump's own party. Republican members of the Senate Intelligence Committee have declined to dismiss the allegations as politically motivated. Senator Richard Burr, who served as committee chair during the previous administration, stated that mishandling classified information is disqualifying conduct regardless of political affiliation. Senator Susan Collins, a moderate Republican, has called for full transparency and accountability. When members of the same party begin using terms like disqualifying and accountability, it reflects a recognition that the evidence cannot be ignored or dismissed. The implications extend beyond individual criminal liability. The intelligence community operates on the principle that classified systems are inviolable. When a former president is credibly accused of retaining and mishandling hundreds of classified documents, it sends a message to current and former officials that the rules may not apply uniformly. Career intelligence officers who have been prosecuted for far less serious violations see the disparity and question whether the system treats everyone equally. That erosion of confidence destabilizes the institutions designed to protect national security. Federal Statute Title 18, Section 793 lays out the criminal penalties for unauthorized retention of national defense information. The law provides for fines and imprisonment of up to 10 years per violation. When prosecutors charge multiple counts related to multiple documents, the potential exposure increases exponentially. Legal experts note that defendants facing dozens of counts often plead guilty to avoid the risk of trial convictions that could result in decades of incarceration. That calculation applies regardless of the defendant's former position or current political ambitions. But that's not all. The Senate resolution includes a provision that triggers automatic referral to the House Judiciary Committee if resignation does not occur within 30 days. House procedures allow for impeachment inquiries to begin with a simple majority vote. Once an inquiry is opened, subpoena power becomes active and witnesses can be compelled to testify under oath. The House has already indicated it is prepared to move forward if the Senate demand is ignored. This creates a scenario where multiple branches of government are moving simultaneously toward accountability mechanisms. Meanwhile, public opinion has shifted in ways that complicate any political defense. Polling conducted after the classified document revelations shows that a majority of Americans, including a significant percentage of independents, believe that mishandling classified information disqualifies someone from holding federal office. This is not a fringe position. It reflects widespread understanding that national security cannot be treated as a political bargaining chip. When voters across the political spectrum agree that certain conduct crosses a red line, elected officials take notice. The convergence is rare and powerful. Federal prosecutors are building a criminal case. Congress is demanding resignation and threatening impeachment. Intelligence officials are warning that the damage to national security may be irreversible. Members of Trump's own party are declining to defend the conduct. Public opinion is consolidating around the view that accountability is necessary. Every avenue points toward the same conclusion. Courts assess obstruction by examining whether the defendant took affirmative steps to conceal evidence after being legally obligated to produce it. When documents are moved, hidden, or retained after a subpoena, prosecutors argue that the conduct demonstrates intent to obstruct. The legal standard does not require that the obstruction be successful. It requires only that the defendant knowingly took actions designed to impede the investigation. Federal judges have consistently ruled that obstruction charges can proceed even when the underlying materials are eventually recovered because the crime is the obstruction itself, not the success of the concealment. What makes this even more destabilizing is the international dimension. Allied intelligence services share classified information with the United States based on trust that the materials will be protected according to agreed-upon protocols. When those protocols are violated, allied nations reassess whether they can continue sharing sensitive intelligence. That reassessment has real consequences. Military operations depend on real-time intelligence sharing. Counterterrorism efforts rely on coordinated surveillance. When trust erodes, the flow of information slows, and American national security is weakened. The focus now rests on whether the Senate will follow through on its demand. The resolution is not binding in the sense that it cannot force resignation, but it carries enormous political and historical weight. When more than 100 members of Congress formally declare that a former president's conduct is disqualifying, it creates a record that historians and legal scholars will reference for generations. It establishes a standard of accountability that future leaders must reckon with. Add to this the reality that criminal prosecution and impeachment are not mutually exclusive. The Justice Department can pursue charges while Congress pursues impeachment. The Constitution does not require one process to wait for the other. This means Trump could face simultaneous legal and political accountability mechanisms, each operating on its own timeline and according to its own rules. That dual pressure is historically unprecedented for a former president seeking to return to office. Federal prosecutors have a reputation for methodical case building. They do not move forward with charges unless they are confident in the evidence and the likelihood of conviction. The grand jury process allows them to test witness credibility, review documentary evidence, and refine their legal theories before committing to an indictment. When that process extends over months, it signals thoroughness, not weakness. Prosecutors familiar with classified information cases emphasize that the deliberation reflects the complexity of the evidence and the seriousness of the charges, not any reluctance to proceed. The timeline is accelerating. The Senate resolution sets a 30-day deadline for resignation. The grand jury is expected to complete its work within the same time frame. Congressional committees are scheduling hearings to review the intelligence community's damage assessment. All of this is happening simultaneously, creating a convergence of legal, political, and institutional pressures that leave no viable path forward for dismissal or delay. Experts warn that failure to enforce accountability here risks normalizing conduct that has always been treated as disqualifying. When classified information is mishandled and no consequences follow, it signals to current and future officials that the rules are negotiable. That precedent weakens every safeguard designed to protect national security. Constitutional scholars argue that the integrity of the classification system depends on uniform enforcement. Without it, the system collapses into selective prosecution and political calculation rather than principled application of law. History provides a clear comparison. When Richard Nixon faced impeachment over obstruction of justice and abuse of power, members of his own party eventually told him that the votes for conviction existed in the Senate. That reality forced his resignation. The current situation involves even more serious underlying conduct. national defense information rather than political surveillance, and a similar erosion of party support. The parallel is not exact, but the trajectory is unmistakable. As legal analyst Glenn Kirshner has emphasized, the rule of law cannot function if it applies differently based on political position or public profile. The Constitution establishes that no one is above the law. Federal statutes protecting classified information exist precisely because the stakes are so high. When those statutes are violated, enforcement must follow. Anything less undermines the foundation of constitutional democracy and the principle that laws bind everyone equally. The coming weeks will determine whether American institutions can enforce accountability against a former president who refuses to accept the legitimacy of oversight. The Senate has made its demand clear. Federal prosecutors are moving forward with their investigation. The intelligence community has documented the damage. The question is no longer whether the violations occurred. The evidence is overwhelming and public. The question is whether the system designed to hold leaders accountable will function as intended. This is not simply a political fight. It is a constitutional stress test unfolding in real time. The outcome will define how future generations understand the balance between executive power and the rule of law. It will determine whether classified information protections are enforceable against those who once held the highest office. It will establish whether Congress can compel accountability when national security is at stake. We will continue tracking every development, every court filing, every congressional action as this historic crisis unfolds. If this analysis helped you understand what's at stake, subscribe for continued fact-driven coverage. Turn on notifications so you don't miss critical updates. This story is far from over.